Armed Forces Special Powers Act (AFSPA) is an act of parliament which was passed on 11th September 1958. This act provides certain special powers to the armed forces serving in the disturbed areas in the state of Assam, Manipur, Meghalaya, Nagaland, Tripura, Arunachal Pradesh, Mizoram, and Jammu and Kashmir. That means all the 7 northeastern states and Jammu and Kashmir. The main purpose of this act is that since the soldiers serving in the disturbed areas where terrorists and militants are active, they are facing volatile and dynamic situations which need some certain special powers for them to tackle that situation. That means the terrorists and militants do not work according to a certain law. So there has to be a level playing field between the soldiers when dealing with the extremists and terrorists. So certain special powers are conferred upon the soldiers to deal with these extremists and terrorists in an effective manner. So what are these special powers? And this act has received criticism from several sections for alleged concerns about human rights violations in the region where disturbed areas has been declared under AFSPA. And these special provisions has been misused by the armed forces for arbitrary killing, torture, fake encounters, cruel, inhuman and degrading treatment of the citizens, enforced disappearances, rape, sexual harassments, molestation, and other things. So what are the special powers provided to the armed forces under this act in a disturbed area? And these are: security personnel, after giving a warning, can fire upon or use any other kind of force, even if it causes death against a person who is acting against the law. For maintaining public order, that means security personnel can shoot, that is fire upon a person, even aiming to cause death if that person is acting against law and order. So this is very draconian provision. And next power given under this act is that the soldiers can destroy any armed dump, hideouts, fortified positions or shelter training camps from which terrorists carry out armed attacks against the military personnel. And next controversial provision is, even without any warrant, security personnel can arrest a person if he feels that he has committed a cognizable offense. Even with a mere suspicion, the soldier can arrest a person, that is, that citizen is denied the fundamental right provided according to the Constitution. And next controversial provision is, it provides power to the security personnel to enter and search any premise in order to make such arrests or recover any person wrongfully restrained or any arms, ammunition, explosive substances and seizes it. So they are free to enter and search any premise to make certain arrests. So this can be misused by armed personnel to enter in any of the house and indulge in illegal activities like harassment. Security personnel also empowered to stop and search any vehicle reasonably suspected to be carrying a terrorist or carrying weapons. And this is also misused by certain security personnel to loot or to rob the vehicles. At least it is alleged in this way. So for all these acts, for all these doings, the army officers have legal immunity. That means they cannot be prosecuted for all these acts. They cannot be subjected to law or any other legal proceedings under any law. So they have legal immunity. There is a chance that even if they commit any mistake, they are not subjected to law. So these are the special powers that makes the controversial. So since these special provisions confirm extraordinary powers without any accountability to the armed personnel, maybe they are misused by some of the personnel to carry out all those inhuman acts that I mentioned earlier. So these provisions made the act so controversial. From time to time, Supreme Court and government formed various committees and commissions to review the AFSPA. So most important of these committees are Jeevan Reddy Commission in 2005, Santosh Hegde Commission in 2013, and Justice ORMA Committee in 2013. In 2005, Jeevan Reddy Commission recommended the abolition of AFSPA. The committee came to a conclusion that this is a symbol of oppression, instrument of high-handedness. So the committee was set up in 2004 in the wake of intense agitation in Manipur following killing of a woman, Tangjam Manorama, while she was in custody of Assam Rifles, that is a unit of army. After that, the famous Irom Sharmila started an indefinite fast hunger strike and has been demanding the revocation of AFSPA from the northeastern states. Still, she is carrying out hunger strike after 11 years. She has not been free. So another committee, High Power Committee, headed by Supreme Court Judge Santosh Hegde, was constituted in January 2013 to probe 6 encounter deaths in Manipur. That is, whether it is a fake encounter or a genuine encounter. So in this report, that none of the victims has any criminal records. So in this report, it shows that none of the victims had any criminal records. That means it was a fake encounter by the armed personnel. So committee provided certain recommendation that it suggested a fixing time frame of 3 months for the central government to decide whether to prosecute security personnel engaged in extrajudicial killing in insurgency hit regions. So it fixed a time frame of 3 months within which central government has to decide whether to prosecute the security personnel for engaging in extrajudicial killings. So commission also recommended that law needs to be revived every 6 months to see whether its implementation is actually necessary in states where it is being enforced. But this is contrary to the present situation where law has not been reviewed for a long time in Jammu and Kashmir as well as northeastern states. It is continuing on and on since it has been introduced in those disturbed areas. So another committee, Justice ORMA committee, soon after Delhi gang rape case, noted that and recommended that bringing sexual violence against women by members of armed forces or uniformed personnel under the purview of ordinary criminal law. So cases of sexual violence by armed forces has to be brought under the ordinary criminal law. There are two types of laws, that is martial law that is applicable to the armed personnel and criminal law applicable to civil personnel. So the ORMA committee recommended that this violence against the women, the cases of sexual violence against women, has to be brought under the ordinary criminal law to be fair and biased towards the victim. But now it is not under the ordinary criminal law. So committee also recommended that special care has to be ensured and safety of women has to be taken care of after she complained against the personnel, and also this has to be extended to the witnesses. Huge protests has been carried out since then. Irom Sharmila on 2nd November 2000, she began hunger strike and she still not broke her fast. Protests has been going on in Jammu and Kashmir and northeastern states for the revocation of AFSPA, and various human rights activists are raising their concerns of human rights violation by taking advantage of the AFSPA by the armed personnel. And National Human Rights Commission also conveyed the apprehension of misusing AFSPA by the security personnel. But the armed forces and home ministry clarified that they need these special provisions while dealing in a disturbed area, volatile area, without which the armed forces will be demoralized. After all, they are fighting for the country and for protecting the citizens of the country. In such a situation, these special powers have to be provided to the armed personnel to deal with those non-state actors, without which they will be armless and subjected to various restrictions. So please provide your feedback in the comment section whether AFSPA should be continued or it should be abolished, and give reasons for the same. Thank you. Thanks for watching.